This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about DUI law. So driving under the influence, and that can be under the influence of alcohol, but it could also be under the influence of marijuana or some sort of controlled substance. It could also be under the influence of your own medication that you're prescribed. Yeah, you can get pulled over, you can get arrested, you can get charged and tried for that. Calling your questions about DUI law, the 31 Law Call number 256-536-0077. You can also email a question. You can email a legal question on any legal topic any day of the week. You send it to lawcall@waytv.com. And when we get to a show that's on point, we pull some of your questions out, and we have got some of your email questions with us tonight. Getting us started tonight, Will Leake is here, also with Brian Beck. Will does personal injury cases. Brian does criminal defense cases.
You know, right, we're so excited about this show all week. We've got a famous local criminal attorney here with us tonight, whether it be robbery, murder, maybe you're moving age. This is the guy. This is the guy, well, especially DUIs. We're talking about DUIs tonight, and it comes over in the civil side where I've got a drunk driver, hits my client, we maintain an action or whatnot, but oftentimes we're waiting on Brian and his clients to get finished with the criminal aspect of the case. So, Brian, why do you guys, you keep your criminal defendant from testifying? Why is that? You know, if I've got a civil case, I'm suing your client, I'm alleging they're drunk and they're charged with DUI. What is your strategy in that scenario?
Absolutely. You're talking about putting a stay on that civil case, and the main reason is that my client testifying probably isn't always in their best interest. And in a criminal case, they can't be compelled to testify against them. But in a civil case that you're handling, they might be compelled to testify against themselves, and that testimony could be used against them in a correlated DUI case.
Right, so they won't have the Fifth Amendment protection in a civil case. Now,
Exactly.
if they have an underlying criminal case going on, they can hold on until that case is over. But once they come in the civil side, then we can get them to testify.
Okay. We always like to start off with a video. We've got some of tonight's You Make the Law Call. We've got a video here that we pulled off YouTube. Pay attention to the pedestrian that's over here on the left, just waiting to cross the street, maybe for the bus to arrive. Car is about to make a left turn and miscalculating how fast the oncoming traffic is going. Luckily, that pedestrian is okay. Paying attention is quick with some quick reflexes. But is the driver making the turn at fault, right? Or somebody else, could they claim that the wreck occurred because the other driver was speeding?
Well, there's a couple issues here. Now, Alabama, remember, it's contributory negligent, okay? So we all know, look, the black car is making a left-hand turn, he blew it, or she blew it. The white car may have been speeding, it's snow. They may have, if you're driving too fast for the conditions, did they cause or contribute it? In a contributory negligent state, yes, they could be liable. Let's say that pedestrian was hit. In a pure contrib, then you're going to have issues of did they approximately cause the injury. So we know the black cars is in the mix depending on what law of your particular state.
Okay.
And so again, you can be, if you're driving too fast for the conditions, if speed limit's 55 and that person will happen to be going 45, snow and icy conditions can lower the speed limit, so you can be ticketed or found liable if you're in excess of a reasonable speed for those type of conditions.
Okay. All right, taking your calls and questions tonight about DUI law, driving under the influence. Okay, Brian, maybe give us some starting points, some levels or things like that, some basics on DUI law. What does the average person out there need to know other than don't do it?
Well, that's the first thing I was going to say. Absolutely don't do it. If you think there's any question as to whether you're impaired, just don't drive that vehicle. We have Uber, we have Lyft, we've got plenty of different options that we didn't even have 15 years ago. So that's something that you need to take seriously. You mentioned earlier that you can be under the influence of medication that you're prescribed, and just because you're prescribed that medication doesn't mean you can't take an amount that would make it unsafe for you to operate that vehicle. So it's something you need to keep in mind.
And Brian, what you're talking about is, so there's a couple of different areas they can charge you with. You got the code section A1 or A2. A2 is your BAC level is 0.08 or greater,
Exactly.
so you can be convicted under those circumstances.
That's right.
But let's say under A1, I have half a beer and a prescribed substance. I take that substance, and then that renders me incapable of driving, even though I'm not 0.08. Under those circumstances, I can be convicted under A2, and that's driving under the influence to the extent that I can no longer operate a motor vehicle safely. Is that right?
That's accurate. That's accurate. Absolutely. And then there are other sections, controlled substance, combined influence, controlled substance, alcohol, any substance such as, for example, like an inhalant, something along those lines, that isn't on a controlled substance list. It's not like a Xanax, a bag of spray paint isn't the same thing as a bag of Xanax. So
Right.
you could be convicted for driving under the influence of that substance, such that you can't safely operate the vehicle.
Okay, so in general, do you tell people don't cooperate with police? Now, there are certain things. You have to tell them your name. You have to be pleasant.
That's the question
But-
every lawyer gets at any cocktail party we're at, right?
Do you recommend cooperating? Do you recommend taking the test that the officer asked you to take?
I'm going to give you the typical lawyer answer, say it depends. All
Okay,
right?
what does
I
it
would say
depend on?
always cooperate. I'd say always be polite, always be to the point, always roll your window down all the way, and just, they're human beings, treat them like that, and just, be polite and to the point. Now, you don't have to, you're not compelled to participate in any standard field sobriety test. You're not compelled to blow into anything. Now, it could have an effect on your driver's license on down the road. But at the end of the day, quite often, if you're doing that, all you're really doing is providing evidence that they're going to need to convict you of that crime. So if you think that it wouldn't be to your benefit to do that, to provide that information, be polite, politely refuse, and request to speak to an attorney.
And what you're talking about, if you refuse to cooperate under civilly, you can lose your license.
Sure.
But on the positive side, you might not be providing evidence against yourself, depending on what your condition is.
10 points, exactly.
And by driving on the road, you've gone ahead and signed a contract with the state that you will cooperate and perform a field sobriety if requested to do so. So if you fail to do that, then your license can be suspended under a civil law that you violated a contract with the state.
Yes.
But now criminally, Brian, you don't cooperate. That doesn't hurt you criminally, only civilly, correct?
Correct. And there are certain steps that you can take to address that administrative suspension of your driver's license. As you mentioned, there's two different suspension statutes. There's a criminal suspension, there's an administrative suspension. Criminal suspension only takes place after you are convicted, enter into a plea, found guilty. That administrative suspension can just go forward only on the accusation, and they get that started immediately after your arrest.
And how long would that go on?
Depends on how long, what the circumstances are really, but 45 days after you receive that form, big orange form says AST 60 up in the upper left-hand corner, 45 days after your arrest, your license would be suspended administratively, at least for 90 days.
Okay. Okay.
Now let me ask you this. Now, on the civil side, I had a case where I had to have the Department of Forensic Science come up to testify as to a blood alcohol sample. Took us a long time to get that case tried. We're waiting on some criminal aspects of it. But the Department of Forensic Sciences, now you have a chain of custody. So they take Sharon, they pull Sharon over, they take her blood, goes to the hospital, or maybe it goes down to the Department of Forensic Sciences. You have to show that there's a complete chain of custody to bring that into evidence. And I couldn't get the other side to stipulate, so I had to actually bring someone from DFS up to Huntsville to testify. Is that the typical case in the criminal? Is it in the criminal situation?
Rarely is that so. Usually, what we're using are the circumstances behind the arrest, the circumstances behind the standard field sobriety test, maybe something dealing with a refusal on the Draeger, maybe the machine was malfunctioning, something along those lines. There's a lot of different aspects that we'd look at in the criminal side of it that we would be less concerned with chain of custody in a criminal case, generally speaking, for a DUI.
Okay, we've got callers waiting. We've got James on the line with a question from Florence. Hi, James. Thanks for calling. What's your question tonight? Hi, James. Thanks for calling. What's your question tonight?
Yes, I have insomnia, and I am prescribed from my regular doctor Klonopin to take at night for sleep.
Sure.
So my question is, I just take it as directed at nighttime. So what if it's like 10 o'clock the next morning and I were to have a wreck? Would that Klonopin be in my system with that concentrated amount, or would it be, would I be innocent, not under the influence?
It's a good question. You wouldn't even have to have a wreck, right? If he got pulled
Correct.
over and they think that he's under the influence of something,
Absolutely.
could Klonopin cause him to get a DUI charge?
You better believe it. Absolutely. Absolutely. Especially, let's say that you were to get pulled over and they find your pill bottle there, and that's your prescription. That is your medication that you've been given that you can carry around with you wherever you like, and take it as directed. And now, that doesn't mean that you can't take Klonopin such that you can't be impaired by it. So those would be questions of facts for a jury, questions of fact for a judge if it was a bench trial in connection with that, saying, look, I was taking this as prescribed. I was taking it when I was supposed to. I'm used to this, medication. I've been doing it for so long, this, that, and the other. Those questions of facts would come in, and it would be up to the finder of fact to determine whether or not this person was impaired such that they couldn't safely operate the vehicle.
Right, James mentioned that he was taking it if he took it the next day, or what if he was pulled over the next day at 10. Depends on how that particular medication affects you. We've had cases where defendant takes an Ambien, 10 o'clock, affects people different. He or she decides not to go to bed for some reason, they go out driving, they get pulled over. Are they impaired? Well, if the Ambien is in your bloodstream to a therapeutic level that, again, just like Brian said, renders you incapable of safely operating a motor vehicle, whether it be on A1 under the statute that you're just too impaired to safely operate a vehicle. So we've had those cases where it's an accident. The patient or defendant takes medication intending to go to bed, somehow loses their mind, or the medicine takes over and they drive the car. So you can be convicted of a DUI and be charged civilly as well for any damage or injuries you cause. Same thing the next day. If your body doesn't metabolize it well or it stays in your system, you could be pulled over, even if it's in a minute minute percentage of your blood. If the officer performs the field sobriety test and you fail that, Brian, you can be charged and convicted under those limited circumstances, right?
Absolutely.
Okay, they're telling us to take a break. We're going to take a break, be right back talking more about DUI law. We'll even talk about some of the diversion programs and things that are out there, but we'll also talk about penalties too. Stay with us.
You're watching WAAY 31 Law Call, where lawyers come to help. Your rights, your calls, live. Hosted by family law attorney Sharon Dovian, with the personal injury attorneys of one of the Valley's most respected law firms, Timberlake and League. Featuring the knowledge of managing partner Michael Timberlake, with millions of dollars awarded to his clients. And the experience of attorney Will League, a strong courtroom fighter known for his commitment to winning. And the fellow partners of Timberlake and League Heath Brooks and William Meservey. This is WAAY 31 Law Call.
Welcome back. I'm Sharon Doviat. Got with me Will League and Brian Beck. Will League does personal injury cases, so everything from medical malpractice to car crashes. Brian Beck does criminal defense, and tonight we're talking about DUI law. We've also got another You Be the Judge video. Walk us through this one.
It's this video, we saw it earlier, it's particularly offensive, and it's failing to taking care of your equipment. And so basically what we've got is we've got a skydiver here who turns out to be our guest, Brian Beck. And
This is what you do in your free time?
And what you're going to find is...
my target.
Here we go.
It's going to be just fine. Everything's going to be just fine.
There he goes.
Look at you.
Look, notice he's got both of his shoes on, right? When he started off. Now, here is well, first of all, what he's doing is crazy. But we got to get to the negligent part. There goes his shoe.
There it goes.
So what if you're down below that?
So had his shoe landed on somebody. Now,
Call
first off,
Will League for all shoe-related injuries.
That's right.
Where are you doing that? Is that up around Chattanooga or somewhere?
I'm judgment-proof, though. I'll tell you right now. You ain't getting no money out of me. I'm sorry.
Good for you. How long you been hang gliding?
About 2 years now.
Yeah, was that up around Chattanooga or somewhere
That
else?
was actually Keel Mountain. That is in beautiful Gurley, Alabama.
Really?
Yeah, 20 minutes from right where we're sitting. Yeah.
So you ended up finishing the flight without your shoe? Did you ever find
such
it?
as it is. Oh, no, that's gone.
It's gone?
That shoe is gone.
Okay.
Impressive.
Somewhere on Keel Mountain.
Well, I've handled, multi-plaintiff litigation cases, bus wreck cases, class action cases, but when you got things falling out of the sky, there can be liability of those who do it, airplanes, whatnot, hang gliders. So we had to.
Good luck.
We had to bring the hang glider in tonight.
Not a penny.
We're talking about DUI law, and that's particularly Brian does that all day, every day, criminal law cases.
You weren't drinking during that, right?
Is that camera?
You're right. Okay.
We've got callers waiting. Jimmy is on the line with a question from Decatur. Hi, Jimmy. Thank you for waiting. Oh, I think we lost Jimmy.
Hang up.
Maybe we'll get him back. Jimmy, are you there from Decatur? Okay, Jimmy was calling in with a DUI question. One of the things he was talking about was that he had gotten a diversion program. So he had been charged and he had a lawyer and he got into a diversion program. So we don't know the details of what is he talking about, a diversion program.
Well, a diversion program, and they have these both at the city level and they have them at the county level as well. The diversion program is essentially like pre-probation. You go to some classes, you jump through some hoops, specifically for a DUI.
Okay.
You go to some classes, you jump through some hoops, you pay some fines, fees, and costs. You might have an ignition interlock placed onto your car. You'd pee into a cup and pay for the privilege to do so whenever they say so. But at the end of the diversion program, unlike probation, the case would be dropped. Null pros, which is just another term meaning dropped. Eligible for expungement, which would be a separate legal process by which you can make that legally as if it never happened. So
Great.
sometimes that's a good idea, sometimes
And to
maybe
be
not.
eligible for that, pretty clean record. You can't have a prior DUI, no other prior whatnot on your record.
Exactly.
Okay.
Exactly.
We've got this email question that may play into this some. Okay, so we got an email question from Chris. Chris wrote in, my wife had an accident at a four-way stop. The responding officer asked if she was drinking. She said she'd had one drink 3 hours prior. He conducted a heel-to-toe test and determined she was impaired and arrested her on suspicion of DUI. Now, my wife is 77 years old, has a clean driving record, and was wearing flip-flops at the time. Apparently, these factors weren't considered. At the station, she blew a .014 BAC, blood alcohol. I was told to retain legal counsel to assure the DUI charge is dismissed, but can't we represent ourselves on this? I find it difficult to pay thousands for a case that should be dismissed. She was not impaired, and the BAC test proved it. Please respond.
A lot of issues in there.
Very much so.
What do you start with? Does he need a lawyer?
Will pointed it out earlier. A1, under A1, it's not necessary for the city or the state to prove that BAC. Now, he says that it proves that her BAC was below the legal limit under A2, but that doesn't mean that the city or state would not be able to proceed with that case at a trial. And if you're representing yourself, then the judge is going to ask, what's your command of the Alabama Rules of Evidence? You know, do you know how to properly impeach a witness? You know, tell me about the hearsay rule. And if you can't answer those questions, then, you know, it's going to be difficult for you to proceed with your case. You know, and the average layperson is not going to know those answers any more than I'm going to know how to remove your gallbladder.
Right. I mean, it's fatal. It's fatal for a defendant to go in there and go against a district attorney who knows what they're doing. They can't keep out evidence. They can't question witnesses. They may, but they probably cannot. And so if you don't know the ins and outs, it's difficult. You know, guys like Brian, they're not crazy expensive. Now, when you're talking about Liberty, now get it. She was 77 years old. She probably wasn't drinking. Brian could sort that case out. But you got somebody with security clearance. We live in North Alabama, Redstone Arsenal. And if you get a DUI conviction, what does that do to your security clearance? And so oftentimes these questions are not just a question of diversion, but if you're convicted, you've got a civil penalty of maybe losing your clearance or your job, depending on, you know, what you're working on. So Brian, in the range when you're talking about DUIs, first DUI, second DUI, third, fourth can be up to a felony. So how do criminal lawyers charge for cases like these?
Well, quite often that is what we go by. You know, is the outcome that we're looking for quite often. What are the outcomes that are going to be available to us? You know, is there something that we'll be able to exploit to our benefit in connection with this case? What kind of criminal history do we have? Do we have other civil aspects like the administrative suspension of driver's license? Is that something we're going to have to address as well? Who are the witnesses to the case? Was there an accident? Were there injuries? You know, there's a lot of different things that move things along that sliding scale for a fee structure for someone like myself.
Right, and you know, in terms of hiring a criminal defense attorney, you go it alone, you're convicted, you're off, you're not making any money anyway if you're going to prison or jail. So I get it. I've forgotten who Chris who was emailing in, but that is not the way to save money. It really isn't.
That's a good point.
And then he's about to have the civil case as well because there was an accident, right? So if she loses, are we going to hear about that in the civil case if you're representing somebody for the civil case?
That's right.
Is that coming in?
We're looking not only, it absolutely is coming in. That conviction is coming in to, you know, we use that. We use similar to the prosecution, how they prosecute their case. We're doing it on a civil. Now, we do not have to show beyond a reasonable doubt. So the big difference between what Brian does and what I do is the burden of proof. You've all seen on TV beyond a reasonable doubt for criminal offenses. But in Alabama, for civil, it's to your reasonable satisfaction. So a lower threshold, a level of proof. And so that makes a difference. It makes it easier on the civil side to get a verdict, whereas on the criminal side, it has to be beyond reasonable doubt, and those questions can be quite important in both arenas, criminal and civil.
We've got Rich on the line with a question from Maysville. Hi, Rich. Thanks for calling. What's your question tonight? Sure.
Well, I was coming back from Chicago, where I was raised. I bought a house down here in Alabama.
Okay.
And I was coming through Fayetteville, and I was speeding, and a cop pulled me over.
Yep.
And when I started to get out of the car, I am a diabetic, and I got restless leg syndrome and neuropathy in my legs. And he seen me grab my leg trying to get out of the car. It was a 2016 Malibu. And right off the bat, he thought I was drunk.
Sure.
And I told him, I said, man, I'm not drinking. I'm just coming back from a trip. And he wanted me to go through some field sobriety. And I had no problem in that. But I told him, I says, I'll tell you right now, I can't stand on my legs and jump around. And he goes, you got proof that you're diabetic and everything? You got neuropathy? I says, yeah, I got a card right there in my license, and I pulled it out and I showed it to him, and he was pretty good. He let me go, but he still gave me a ticket now.
Okay.
But what would happen if something like that happened again and I got a wrong cop?
Or you didn't have that ticket. You didn't have something with
Rich,
you.
it sounds like he did the right thing.
Yeah.
You know, Brian, he told the officer he had a medical condition. He actually had proof. And most officers are nice and cool, want to do the right thing, get you home safe. Sounds like he ran into one that was doing the right thing.
I agree. Sounds like you got the right officer and the right facts. But quite often that's not always the case. You know, they are trained professionals, but they're not medical professionals. You know, they're quite often there might be some condition that you know about that this officer might not know anything about. They're going to ask you about your physical conditions and if there's anything that's going to keep you from participating in those standard field sobriety tests. But quite often, I've seen plenty of people who are sober who just, you know, had a knee issue, a hip issue, and that disguised itself as an impairment issue, and those people went to jail. So,
and going back to the scary thing, under these same facts in Alabama, let's say he had half a beer. He was .002.
Sure.
And he gets out, fails the field sobriety test because of his underlying physical condition, but the officer still, they detect .002. You can still be convicted under the DUI statute in Alabama, A1, correct?
Worst case scenario, absolutely.
Do you see that? Do you see that prosecuted often, or is that a rare scenario?
Not as rare as it should be.
I hear you.
Okay,
Yeah.
let's take a break. We're going to be right back with more of your questions and answers. DUI law. Stay with us. If you didn't get your questions answered tonight, here's how to get in touch with Brian Beck, Law Office of Brian E. Beck, Huntsville. Check out Brian at brianbecklaw.com, and the number is 256-539-0096. Here's how to get in touch with Will League with Timberlake and League in Huntsville, 256-536-0770 or 800-804-2502. The website is law-injury.com, and if you like them on Facebook, you can learn more about the law that way.
And our own Sharon Doviet, family law attorney, Huntsville, 539-7337, SharonFamilyLaw.com.
Thank you, sir. Thanks for all your calls and questions tonight. Fun to have Brian on tonight. Everybody,
Thank you so much.
Thanks a lot.
stay
Thanks
safe. We'll see you next week.